But I really just want to focus on some of the challenges that there might be in talking about harmonization of public procurement rules within the African context. And I think my key kind of thought here is what are the implications of these challenges, and are they barriers, real barriers, or are they just challenges? So I'm going to just very briefly touch on the following few issues. So legal traditions, regional integration, corruption, country procurement maturity, procurement technicalities, e-procurement, SMEs, localization. It's a mouthful, but as I said, I'm not going to go into detail on all of those. But really the core of what I want to say today is that while I think these are all challenges that would require very detailed and careful attention, I think they all also present opportunities that would go towards harmonization of some sort. And I think in particular, they provide us with opportunities to think about the modality of such harmonization and what would be the ideal type or the optimal way of approaching harmonization within the African context. So if we look at varying legal traditions on public procurement over time, then I think this is the point that's also been raised in the chat. What role does very different legal traditions on the continent play in this regard? And I think it is a highly relevant, important point, because just between the three major colonial traditions that continue to have a dominating effect on the continent in terms of our legal tradition, our legal culture, there are very important differences, very significant differences between Lusophone, Francophone, and Anglophone African countries. And it really goes to the heart of public procurement and how we just conceptualize the very nature of a public contract. What is the nature of this beast? If you simply just compare common and civil law traditions, French and English law traditions on the continent, you see in the legal systems that there are really fundamental differences in how we think about a government contract. As a legal mechanism, and then because of that, as an administrative tool. And that's got very particular and important implications for the institutional structures also in each of these systems. And I think those are really important considerations to take into account. That being said, I don't think one should overstate it, because the same, of course, can, to a limited extent, but still be said of the EU as well. Right, where you have less, but certainly also at least until fairly recently, a civil common law divide, and to a very limited extent, still the case. However, I think this particular challenge of deeply ingrained legal traditions that differ fundamentally with high relevance for the practice of public procurement also brings the opportunity that there is accordingly a need for, let's call it, a third-party instrument to be brought to bear on public procurement if we are going to pursue harmonization. That it is not something that will happen because of inherent alignment between the systems on the continent, because there is no inherent alignment. And I think that really then pushes us to think about a supranational approach to designing some harmonization across all these systems. The second point that's related to that one, and that especially Shope has already spoken to in some detail, so I'm not going to go into detail here, but the various different trade blocks and free trade agreements and areas on the continent has had a very differing impact on how we look at harmonization in public procurement, and the different areas have had very different approaches, so that you find today pockets where there are quite advanced attempts at harmonization, but those pockets differ quite significantly inter se. And the question then is, if you've already gone down that road of harmonizing at a regional level, you'll have to backtrack a little bit if you want to now do it at a continental level. So you'll have to do some dismantling of the regional in order to get to the continental. And the question then becomes, how viable is that? How realistic is it to think that COMESA will backtrack somewhat on the progress that they've made in their harmonization, or the East African community, in order to adjust to a continental regime? And Shorpe, I think, very effectively explained all of these different regimes to you and shown the differences between them. But again, at the same time, I think there are very important opportunities here. And firstly, it's born out of the fact that the notion of harmonization in public procurement is already alive and well on the African continent, right? So
voice is gone.
I cannot hear you anymore.
Here, we lost your sound.
We cannot hear you. Yeah.
Can you hear me now?
Yeah.
Yes.
Sorry, might have pressed the button that I shouldn't have. So the notion of supranational harmonization regarding public procurement is not a foreign one. In fact, it's a practice in vast parts of Africa. So that, of course, creates an opportunity, and very interesting opportunities also when you look at cross membership between these entities. And I think the DRC is such a fascinating example of exactly that, belonging to quite a number of different blocks. And that presents, of course, interesting models and case studies to go and explore and see. But, seemingly on the surface, there are these differences between the regions. But if you've got a country that belongs to all of them, what does that tell us about really below the surface in terms of harmonization? But I think what is then also an important opportunity in this context, in then raising that idea of harmonization beyond the regional, is it tells us something about how one could sensibly go about achieving that. And to my mind, I think it suggests that a combination of a GPA UNCITRAL harmonization approach could then be a sensible one, where at a continental level, you've got nothing more than a GPA type arrangement, where you've got very broad principles that continentally we all agree on. But how those principles are downloaded into domestic systems would very much depend on the regional regime. And that regional regime then becomes something a little bit more like an UNCITRAL approach, where you've got some more stronger model law approach. And that might differ from region to region. But all those regional models would be aligned to the top level GPA type broad principles. I think that could be an approach that could work in the African context. Then a further point that I think, of course, is very, very important, and that most people also already referred to, is corruption. Not just corruption, but procurement abuse more generally. That low levels of integrity is an obvious challenge for any attempt to harmonization. As Caroline has noted right at the outset of our workshop today, harmonization is very much about trust. So when the systems are beset by abuse, such as high levels of corruption in the African context, and we know that a lot of this is tied to procurement, there can't really be trust, and harmonization efforts will suffer. And this is particularly the case when we're talking about the very rules that should be increasing integrity, of which procurement rules are, of course, important, an important dimension. So if you've got low levels of integrity within a system, as we do on the African context, it becomes quite challenging then to talk about harmonizing the very rules that's supposed to be generating integrity. And again, I think there are then important links here also to the remarks already made around the role of economic and political elites that Professor Eukens have raised. Which, of course, in many instances can simply be benign, that role, kind of protectionism, but in many cases, and certainly in the African context, it's not benign, right? There are corrupt relationships between elites and governments, and those relationships often play out in the real world via procurement, and there are strong interests in protecting that position of the elites in the domestic countries, which would be very much contrary to any efforts at harmonization. But again, I think corruption, high levels of corruption, in fact, presents an opportunity for procurement harmonization, because the urgency of dealing with corruption, the fact that there's really no doubt about this being one of our biggest challenges on the continent, really puts more attention to high levels of integrity, really benchmarking rules that's going to generate integrity in your governance system right at the forefront of public discussion. And again, procurement rules must be part and parcel of that conversation. So if we recognize, as we now widely do, that corruption is a major issue, a major barrier to development on the continent, and we start to talk about how are we going to counter this, then talking about better procurement, better governance arrangements for procurement must be at the heart of that conversation. And of course, then that brings a harmonization of some level, if it's then only in terms of integrity, transparency squarely to the table. And I think that's an important opportunity. Another major challenge is the level of country procurement maturity, which differs very, very significantly across the continent. The level of procurement, country procurement maturity right across the African continent is very, very significant. You've got fairly well-developed systems that's gone through multiple iterations of detailed rules, that's experimented with rules over an extended period of time, and it's had the opportunity to fine-tune those. In contrast with really, really fledgling systems, that's only really been operational for a very limited period of time, really in their first iteration of rules. And of course, that becomes a major barrier to procurement harmonization across such a vast and vastly different landscape. But again, I think it brings a very important opportunity to the fore, and that is that it creates the opportunity to leapfrog in terms of experience. So it really presents the entire continent with an important opportunity to say, well, let's not reinvent the wheel. Let's not make the same mistakes. Let's use harmonization as a way to bring good, fit for purpose, best practices to bear within our own country. And I think harmonization can really serve that purpose and can be an important tool to bring maturity to those systems that's still lacking maturity. Then at a more technical level, perhaps, there are a number of procurement technicalities that would be a big challenge in the African context. And terminology is just one very common one. It's not unique to the African context. Of course, terminology is a big issue around harmonization around the world. But if you go and look at actual procurement rules across the continent, it is quite a significant one on the African continent, because the terminology being used in procurement is really extremely varied on the continent, despite the fact that there might be conceptual convergence. It's not always obvious that there is such conceptual convergence because of terminology. So just very, very simple things like bid invitation versus solicitation versus tender document versus request for bids, or qualification versus responsiveness versus acceptable bid versus functionality versus eligibility. And really quite challenging questions around whether those are conceptual differences or simply just terminological differences. And in this word cloud, I've just pulled 5 random African procurement statutes together into a word cloud instrument to just generate this picture. It turned out to be less interesting than I thought it would be. quite interesting that the word shall comes out as really the big thing. It tells you perhaps a little bit about the paradigm of procurement law on the continent. But then also talking about major differences in procurement methods, and there are significant differences: open bidding, open domestic bidding, open international bidding, quotations, closed bidding, restricted bidding, RFQs, invitations for expressions of interest, single source, sole source, direct procurement, two-stage bidding, transversal contracting, force account. So that there's really an extremely broad menu of procurement modalities at the moment in play, and cutting through all of that to get to some form of harmonization is of course quite challenging. And then finally, of course, major structural differences. And here we come back to the legal traditional divide on the continent, that of course the legal structures and with that administrative structures also follow quite closely those traditional legal divides, so that it is quite challenging to even just talk about the institutional architecture if you compare any Northern African procurement system with anything in Southern Africa, and I think that's quite a difficult thing to manage. But again, I think very important opportunities are born from these technical difficulties. It forces us to cut through superficial barriers and to really engage at a conceptual level to get conceptual agreement. So conceptual alignment may thus be hidden by structural and terminological differences, and harmonization can really help us to explore those conceptual agreements, that those conceptual alignment, and may help us discover that there's in fact higher levels of conceptual convergence that we might at first glance realize, so that a deliberate and structured exercise of seeking harmonization may just bring that to the fore, and I think that in itself will be quite useful. Then talking about e-procurement is another very important consideration and challenge in the African context. And if you are talking about any form of integration as a driving force behind harmonization, then e-procurement becomes an important modality and tool. And in the African context, e-procurement is very, very seriously lagging behind almost all other regions in the world, in the sense that public procurement on the African continent is still very much a manual process. And of course, that would be a major challenge if we start to talk about harmonization and any form of integration following it, if we do not do any extensive form of e-procurement. If you can't even have sight of local procurement practices, then it becomes, of course, very difficult to talk about harmonization of any nature. But again, I think important opportunities, because harmonization can really push efforts at a continental scale to get e-procurement off the ground. So because e-procurement is still very much lagging behind, many African countries do not face major legacy barriers in adopting e-procurement solutions today. So that if rather than driving e-procurement efforts at a country level, we can drive it at a higher level, even continental, through a harmonization exercise, I think there are significant advantages to be had in bringing e-procurement practices to bear on the continent in a much quicker way, and avoiding typical legacy issues that you find in many other systems. Then focusing on small and medium enterprises, again, a consideration that's been raised by a couple of authors today. And we know, of course, that on the African continent, small and medium enterprises really comprise the vast majority of economic operators. Estimates vary up to 90% of all economic activity on the continent being through SMEs. They're estimated to employ up to 80% of the workforce on the African continent. And when that's the reality, it raises some interesting and important questions around SME participation in public procurement, not just at a domestic level, but at a cross border level where harmonization would mostly play out. And the question then is, if harmonization is about integration, about greater cross-border or greater interaction, are there any real viable benefits to be had for most African economic operators, given that they are mostly SMEs? It also raises some interesting questions around the use of thresholds in many of harmonization approaches. But again, I think the opportunities behind the realization that the vast majority of economic operators on the African continent are SMEs tells us something just about the form or the modality of harmonization, as opposed to whether one should approach harmonization or not. So I think it suggests to us that high levels of codification of a single instrument at a supranational level in order to pursue market integration might not be as realistic as one would think in the African context, and that cannot be the objective. But that harmonization, in the sense of having similar rules at a domestic level in the UNCITRAL type form, might actually be quite useful in terms of getting investment in to the market. So I think that tells us something about an appropriate approach to harmonization. And then the last point I want to just talk to is the one that I think many speakers and certainly Dominic has also referred to, and that is localization, which is such a dominant phenomenon on the African continent. So localization through procurement is really very, very common on the continent. And a very large number of African states have explicit localization mechanisms built really into the heart of their procurement system. It's really a paradigm. And these include both straightforward economic localization preferences to local suppliers, but also, I think, more problematically from a harmonization point of view, preferencing local suppliers through indirect mechanisms where the main aim is not economic advantage to local suppliers, but something else, like, for example, gender or youth or disability, or as is quite often the case, particular ethnic or marginalized groups within a particular country. And when we look at those mechanisms on the African continent, we see that they are, with very, very few exceptions, they are also linked to nationality. So it's not simply a matter of promoting female suppliers. It's a matter of promoting South African female suppliers, and that's the common paradigm. Now, that of course is highly problematic, and it raises questions around what is indeed the policy objective behind those kind of mechanisms. Is it purely a gender one in that example, or is it a domestic gender policy consideration? Of course, those are different policy considerations. So from South Africa, with its very extensive preferential procurement regime and local content requirements in the south, to Kenya, with its preferences for local suppliers and thresholds for employment of local people under procurement contracts, to Nigeria, with its margins of preference for domestic bidders. Right across the continent, you find this as a paradigm. And I think this is perhaps where the African Continental Free Trade Agreement and area really comes to the fore, because it might just force us on the continent to reimagine our notion of localization, and perhaps start to think about localization on a continental scale as opposed to a domestic scale. And this really brings me back to the point that I made in the previous session as well, that when we talk about harmonization as a way of integrating the procurement markets, it might not be viable or feasible or even desirable for us in the African continent to talk about global integration. But it might be quite feasible and desirable to talk about it at a continental level. And if that's the case, I think it brings very interesting questions to the fore about what are the instruments going to be that's going to facilitate this process of continental harmonization for a continental agenda. And I think that's, for me, where the biggest interest at the moment lies. So I will stop there